Hi, my name is Allison Grosz. I'm a partner with Hemrick PLLC located in New York, New York. I want to talk really briefly today about a question that I get fairly frequently from many clients who are going through what's called removal proceedings. Removal proceedings is just another way of describing what people go through when they are presenting themselves before an immigration judge in the immigration court. There are various immigration courts throughout the United States. The question that I receive very, very frequently from clients is, what is the difference between administrative closure and dismissal without prejudice? So I'm going to talk about this for a second. There are various reasons why people might be eligible in immigration court to either administratively close or pause their case before the immigration court, or dismiss their case without prejudice before the immigration court. Administrative closure means that your case remains in the immigration court. However, it's put on a top shelf and it's necessarily forgotten about until something else happens. As an example, if somebody is before the immigration judge with a pending application for asylum, but then they marry a U.S. citizen, we may ask the immigration court to administratively close their asylum case while the U.S. Citizenship and Immigration Services processes their marriage petition from their U.S. citizen spouse. One other thing that might result in administrative closure is if a person has any other sort of pending case before a different government agency, and the immigration court allows time for that government agency to make a decision on that case before the immigration court will proceed with their case. For that reason, when a person administratively closes their case, they're not scheduled for any future hearings until either the respondent, which is the immigrant, represented by an attorney such as myself or other attorneys with Hemrick PLLC, or the government attorney, meaning the Department of Homeland Security, requests to recalendar the case for some reason. What's good about administrative closure is that a person gets to maintain their employment authorization, if they have employment authorization, based on a pending application for relief from removal proceedings at the time that the case is administratively closed. Now, alternatively, there is dismissal without prejudice. Dismissal without prejudice is sometimes formally referred to as termination of the case from the immigration court. And all that means is that the case no longer exists within the immigration court. This is very common in various circumstances and for various reasons, but one common example is, let's take that marriage case. A person filed for asylum. They're before the immigration court. They marry a U.S. citizen. That U.S. citizen files a petition with the U.S. Citizenship and Immigration Services, which is then approved. You can then go to the immigration court and ask them to dismiss your case without prejudice so that you can apply for a green card with USCIS. What that means is your case is dismissed. It no longer exists before the immigration court. This gives more opportunities for the immigrant, for the individual, to pursue their green card application before a different agency, the United States Citizenship and Immigration Services, rather than before the immigration court. Because many times, especially nowadays, with the immigration courts as overburdened as they are, it's very difficult and could take a very long time to be scheduled for a proceeding to be granted a green card. So rather than waiting for the immigration court to do that, you could ask them to dismiss your case without prejudice or terminate your case and apply for that same green card with the U.S. Citizenship and Immigration Services, which is also called USCIS for short. So that's the difference between administrative closure and dismissal without prejudice. Of course, there are a lot of nuances to this. There are a lot of details that go into whether somebody is eligible for either one of these two options before the immigration court. Of course, you should always seek advice from a qualified immigration attorney. We here at Hemrick PLLC represent people in these sorts of requests, as well as all sorts of other immigration matters, and we are happy to hear from you. Anyone can contact us anytime by phone at 833-848-7838, or they can send us an email at info at hemrick.law. That's INFO at Hemrick, HEMRICK.law, LAW. Thanks, and looking forward to talking to you all soon.